What is MS? Depending upon who you ask, the answer might be a title of respect prefixed to a woman's name, like the one used as the title of a well-known liberal feminist magazine, or the U.S. Postal Service abbreviation for the state of Mississippi, or an acronym for multiple sclerosis, the disease that impacts the brain and spinal cord, or a Master of Science degree. But in a recent dispute under the UDRP, the Uniform Domain Name Dispute Resolution Policy, the answer was none of the above. The UDRP complaint in this case was filed at the Forum by Morgan Stanley, the financial services firm that has more than 1,000 offices in over 40 countries, 55,000 employees, and annual revenue of $48 billion. The dispute involved the domain name ms-management.com, which, according to the UDRP decision published in February 2022, was being used by the respondent in connection with a phishing scheme that sent fraudulent emails containing Morgan Stanley's trademark, logo, and physical address. Common tactics employed by cybersquatters trying to imitate someone else, often with the intent of getting someone to pay a fake invoice or to send payment for a real invoice to the wrong account. Now, phishing clearly constitutes bad faith under the third element of the UDRP. But what makes this case interesting is not how the domain name was being used, but what the domain name itself actually contained, the letters MS. According to the decision, Morgan Stanley has rights in the trademark Morgan Stanley through a 1992 registration at the U.S. Patent and Trademark Office, the PTO, as well as other registrations worldwide that make the Morgan Stanley mark famous. But interestingly, the UDRP decision does not refer to any trademarks for MS owned by Morgan Stanley, based on registrations or common law rights. Morgan Stanley does use the domain name ms.com, but as I said in a recent video, use of a domain name alone does not give a complainant trademark rights for purposes of the UDRP. In fact, although the decision doesn't mention it, Morgan Stanley actually filed a trademark application for ms.com at the PTO back in 1998, but it was never registered and instead was abandoned in 2001 after a final refusal from a trademark examiner. So what's the issue? The reason I'm talking about this case is because of the first element of the UDRP, which requires the party filing a complaint, in this case Morgan Stanley, to prove that a disputed domain name is identical or confusingly similar to a trademark or service mark in which the complainant has rights. And in most UDRP cases, that comparison is pretty straightforward. Most of the UDRP complaints I file involve domain names that contain my client's trademarks in their entirety, perhaps with the addition of one or more other words, or a typographical variation of my client's trademarks, such as adding, deleting, or transposing letters. But in the Morgan Stanley case, the issue is a bit different, and it's one that doesn't arise all the time. Whether an abbreviation of a trademark is confusingly similar to the trademark. Here, the UDRP decision simply says that Morgan Stanley made an argument that MS is a well-known abbreviation of the Morgan Stanley trademark. Now, since UDRP case files are not published, only the decisions, it's impossible to know what sort of arguments Morgan Stanley made on this issue or how detailed they were. The panel's only finding, without any elaboration, is that the Morgan Stanley trademark is commonly abbreviated as MS. As a result, here's what the panel concluded. The disputed domain name consists of the term MS, a common acronym for complainant's business name Morgan Stanley and mark Morgan Stanley, a hyphen, the descriptive term management, and the gtld.com. These changes fail to sufficiently distinguish a disputed domain name from a mark per policy paragraph 4A1. Therefore, the panel finds that the disputed domain name is confusingly similar to complainant's mark per policy paragraph 4A1. The panel did cite previous UDRP cases brought by Morgan Stanley that also reached the same conclusion. For example, for ms-clientservice.com, ms-clientservices.com, ms-ae-fund.com, and ms-sb.com. But none of those cases contain much discussion about why or how MS, as an abbreviation, is confusingly similar to the Morgan Stanley trademark. However, There is at least one section of the WIPO overview that could be interpreted as relevant here, even though the panel didn't discuss it. Although it doesn't specifically address the issue of abbreviations, the WIPO overview does discuss the issue of whether the content on a website associated with a disputed domain name is relevant when considering whether the domain name is confusingly similar to a trademark. Specifically, here's what the WIPO overview says. In some instances, panels have taken note of the content of the website associated with the domain name to confirm confusing similarity, whereby it appears prima facie that the respondent seeks to target a trademark through the disputed domain name. Now, although the phishing activity that gave rise to the UDRP complaint for ms-management.com is not a website, the intention is the same. The respondent's activities related to the domain name indicated an intention that others would see it as being confusingly similar to the domain name. UDRP cases involving abbreviations are not common, or at least not such significant abbreviations as in the Morgan Stanley case, where a 13-character trademark was reduced to only a 2-letter abbreviation. But this case makes clear that under certain circumstances, at least some panels will consider a domain name that contains an abbreviation of a trademark to be confusingly similar to the trademark. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.